Good afternoon.
Good afternoon. My name is Seamus Kelly, here on behalf of the appellant 5D Development, Inc. I'd like to reserve 2 minutes for rebuttal.
2 minutes.
May it please the court, this appeal is about whether trial court orders and procedural rules should be enforced regardless of whether the court believes it knows where the merits are going to end up. In this case, has a pretty convoluted procedural history, but the relevant issues here are that there was a plaintiff, TIMGMT, and the defendant, 5D, who I represent as the appellant. They had a real estate transaction that fell apart. TIMGMT sued 5D. 5D answered and filed a counterclaim. Later, 5D learned of some other entities that it wanted to include and received leave of the court to add some third-party defendants. Now, after serving the third-party defendants, the counsel for 5D and the counsel for the third-party defendants reached an agreement to allow an extension for the third-party defendants to answer the complaint.
To file a responsive pleading.
Exactly, file a responsive pleading. And that language is very important, Your Honor, because a responsive pleading is clearly defined under Rule 7. It's further separated from a motion to dismiss under Rule 12. So
the key here is that you granted, or the parties agreed, that the defendants had an additional period of time to file a responsive pleading, but their argument is that order did not prohibit filing of a motion to dismiss or other.
Correct, Your Honor.
Or motion. Correct.
And it certainly did not. They're certainly able to raise those issues in a responsive pleading or a motion to dismiss if they so felt. The issue is that they ignored the order saying you are required to file a responsive pleading by this date, and importantly, I don't want this to get lost, is that they were supposed to respond to discovery on that same date of February 29th, 2024, because I want to make it clear, this isn't just, this isn't just send it back so they do a better assessment. It's, we believe that had the proper procedure been followed, we would have had grounds through the discovery we received to make an effective amendment to the third-party complaint. And that's why the procedure is so important here.
Well, what if they had filed a responsive pleading and they asserted the affirmative defense that they raised in the motion to dismiss? What's the difference?
Well, the difference is notice and whether there's a dispositive motion on the table. The important part is that had the third-party defendants obeyed the language of the order that said, on February 29, 2024, you will file a responsive pleading, and you will file, you will respond to their discovery.
Well, don't the rules also say if you want to file a motion to dismiss, you should do that before you file a responsive pleading?
Yes, Your Honor, but also...
So if they had that extra time to file a responsive pleading, then under the other rule, they were to file their motion to dismiss before they filed that.
Yes, Your Honor, but Rule 12 also clearly states that unless a different time is fixed by order of the court for filing a responsive pleading, and here we had an order that the law of the case stated a responsive pleading is to be filed by this date. So that's the plain language of Rule 12, that if you're going to file the responsive pleading, you don't have to file if you file the motion to dismiss, you don't have to file the responsive pleading until 15 days after it's resolved. But in this case, there wasn't a fixed order with the date.
I'm interested in your comment about how additional discovery might have impacted the analysis here. The motion to dismiss seemed to be founded primarily on a provision in the purchase agreement that seems to exclude claims against these third-party defendants. How would have additional discovery aided in combating that defense?
So through discovery with the original plaintiff, as this case has carried on, we've seen some evidence that suggests that there was an assignment to these third-party defendants. And the contracted issue, I agree, if they're purely affiliated companies, it does exclude affiliates from liability, but it does not exclude assignees. It says assignees will be bound by these same terms, and we found communications between these parties that certainly implies an assignment from our perspective, and that's why with our motion to revise, we attached an amended complaint demonstrating that this would not have been a futile amendment had procedure gone correctly, and had the court appropriately assessed each of the factors for each of 5D's arguments.
So when TIMGMT Acquisitions filed its complaint, did 5D raise the defense that it's not the real party in interest?
It did not have that knowledge at that point, I believe, Your Honor. So moving on to
Now, the case had been pending for, what, a year and a half?
Correct.
Before the third-party complaint was filed.
Correct, Your Honor.
So why didn't the earlier discovery reveal this? Because you had the contracting party before you for a year and a half, and you could have asked them, have you assigned this contract?
Yes, and there were a lot of procedural delays in this matter. I'm the fourth counsel representing 5D, not that that's an excuse.
Right.
But there were certain procedural delays that delayed discovery in this case.
Which kind of leads to the question of why was this extra 30 days so critical that the planet was going to, or that we were going to fall off the edge of the earth if something didn't happen on this 30th day? Well,
Again, Your Honor, part of the agreement, an important part of that order, the agreed order, was that they were going to receive discovery responses. That ordered date was February 29, 2024.
And you filed multiple motions to set this aside, to deal with the discovery issue, and the trial court, exercising its discretion, ruled against you on every motion. So we review every one of those decisions subject to the abuse of discretion standard. So you don't have just a high hurdle on one issue. You've got a high hurdle on 4 or 5.
Agreed, Your Honor. And I understand the abuse of discretion standard does make it more difficult for us. However, as the Harmon case states, discretionary decisions must take the applicable law and the relevant facts into the account.
Correct.
And the trial court simply denied those motions as moot by ruling on the motion to dismiss first,
But
whereas
doesn't a trial court control its docket, and if it chooses to give somebody more time to file a responsive pleading or more time to file a motion to dismiss, it can do that? Isn't that permissible?
I believe that is within its discretion, Your Honor.
What law are you relying on that says the trial court could not do that?
Well, we're relying on the plain language of the order, the agreed
So
order.
you're saying that order removed all discretion from the trial judge on whether these third-party defendants had to file a responsive pleading on that drop-dead date, or they lost everything in this lawsuit. Is that what you're saying?
Oh, no, Your Honor. No, and I don't believe the
You said
appropriate.
we have to take the law into consideration, and I'm trying to figure out which law you're relying on that says the trial court couldn't do that.
Certainly, Your Honor. So I would say, and by applying the Convalinka factors towards the first motion and I believe it's the Looper factors for those, that had the court gone through those assessments and presented a rationale for denying those motions, then that was within the court's discretion. But ruling them moot because those were purely aimed at, is this motion dismissed properly before the court?
Mm-hmm.
And by addressing the merits of the motion to dismiss prior to that and then mooting them out, that didn't give 5D the full opportunity to use all the tools at its disposal, such as moving to amend. If they said, okay, this motion to dismiss is still going to be there. We got to amend this thing. This is a pretty strong motion to dismiss.
So you would say the abuse of discretion here is because of an error of law and fact?
Yes, Your Honor.
And what are those errors? What are the errors of fact here that were involved, and what's the error of law that the court committed?
So the facts that are relevant, I think, are the timing of things and when they were filed. But it is primarily the law here, which is that the law states even though when you're looking at the abuse of discretion standard, they need to the court needs to lay out the factors as to why they reached their decision. And by not doing so and instead relying on mootness, instead of looking at, well, is this waived? Have the third-party defendants failed to obey an order of this court by not producing discovery, by not filing responsive pleading by the date specified in an order?
Well, but isn't the implication in the court's order by granting the motion to dismiss that the court did not find that their order was violated?
Sorry, in which order was that?
Well, in the agreed order setting the deadline.
So the agreed order setting the deadline, the court, and it depends on the court's interpretation of responsive pleading. And we believe responsive pleading is that Rule 7.
Only an answer.
Essentially, or the variations of an answer.
So you mentioned Aylor case in your brief.
Yes.
Which to me seems to completely undercut your argument about whether or not a motion to dismiss can be a responsive pleading in this context. I mean, I know that we've said it can be a responsive pleading or would not be responsive pleading for the purposes of 1501, but in other contexts, it could be a responsive pleading. So why doesn't that end your argument on the point?
Well, Aylor was aimed at a very specific statute. It actually took the legislative intent under consideration.
But if I was looking to interpret a court's order and what it actually meant, I certainly would be looking at Aylor.
And I understand that, although it's aimed at a statute that does not apply here. Yeah. It's aimed at a statute regarding special procedures for suing state actors, which was not the case here. So we think it's inapplicable. It's interpreting language in that specific statute, saying the legislative intent of this specific statute was to expand other responsive pleadings to include motions to dismiss. Here, this is just, hey, by the rules, we're giving this extension. And I think one point I want to make before my time's up, Your Honor, is I don't want us to chill collegiality. I don't want, as a plaintiff's attorney, to tell defendants, I got to dig my heels in because I don't want to give you extra time to write a motion to dismiss, because they've had their 30 days. And I think a great thing about the way that this state operates is we give each other collegiality. We say, yeah, take that extra time. But language that is selected matters. And in this case, the language said a responsive pleading and discovery had to be responded to on that date.
All right, thank you. We'll
Thank
hear
you.
from you on rebuttal. Good afternoon.
Good afternoon, Your Honors. John Farringer on behalf of the third-party defendants, or the Electra parties we've been calling them. I do want to note Michael Catone, who represents the original plaintiff and counter-defendant, is here. He has not asked for any time since his parties are not directly involved, but he's here if you have any questions.
Thank you.
The Chancery Court properly dismissed the third-party claims, which were all premised on the allegations of a partnership. If you look at the third-party complaint that was dismissed, it was about there being a partnership. And Section 1318, as previously referenced, specifically said partners are not liable. That's the primary basis for the ruling. And that ultimate ruling is not directly being challenged. Rather, we're arguing about these 4 or 5 other motions that were filed. And we believe, first, that the Chancery Court was correct in deciding at its discretion in managing its docket that those were moot. They were filed after the motion to dismiss. Motion to dismiss was the first thing filed. The court, not only the motions themselves, they were all heard on the same day. So not only were those motions before the court, the response to the motion to dismiss mentioned all these same arguments. The Chancery Court considered all that and decided to grant the motion to dismiss. And as noted, that's, that should be affirmed. And so on the issue of whether those other motions were then moot, that is abuse of discretion standard. That's the Chancery Court controlling its docket, and we believe there should be deference there. If the court agrees with those 2 points, that the motion to dismiss was properly granted and that everything else was moot, then that ends it. We don't have to get into the details of anything else. But I will go a little further in case your honors want. I do want to note the procedural timeline here. The agreed order, which was February 6, 2024, gave additional time for a responsive pleading, as you've heard, and to respond to discovery. This entire appeal and all 4 of the motions that 5D argues about are based on the premise that by sticking the language responsive pleading in there, that it's a gotcha, and you've waived your motion to dismiss. It doesn't say anywhere in that order, you've waived your motion to dismiss. It doesn't say you must file an answer. It says responsive pleading. And that the only basis, the only law cited to support this idea that a responsive pleading means you've waived your right to motion to dismiss are all Rule 15.01 cases, as Judge McBrayer pointed out. And I believe this exact panel decided the Ayler court case, and it's already been referenced, so I won't go into too many details, but we think the Ayler case, what it stands for is that 15.01 is the unique situation where a motion to dismiss is not a responsive pleading and you get to amend. There's no cases outside of 15.01 that say you've waived a motion to dismiss. There's not a single case cited in Tennessee or outside of Tennessee by appellants that if there's an extension and use the word responsive pleading, you've waived the motion to dismiss. That there's no cases supporting that. And I think most importantly for this court, that's not what the Chancery Court, that's not how the Chancery Court interpreted her own order. It was an agreed order, an agreed extension, but there was an order put in that the judge signed. And the judge had all these arguments before the court. When deciding all this, the judge clearly interpreted her own order using the word responsive pleading not to preclude a motion to dismiss. And that should be deferred to under the abuse of discretion standard.
And did the motion to dismiss come within the time provided for filing responsive pleadings?
It did, Your Honor. And I do want to correct one thing. I'm not sure it matters, but there was also discovery provided in the time frame provided.
Now the appellant, if I heard him correctly, suggests that your clients failed to respond to discovery within the time.
And that's why I wanted to mention that, Your Honor. That is not correct, and I think is reflected in the record. I'll note I want to provide a citation, if Your Honors will. Volume 9 at page 1250 to 1252 is one of our pleadings, and we provide in there a timeline that could be helpful to the court about when these discussions occurred, when discovery was provided. To the extent it's relevant, I want to point the court to that. We did respond to discovery. There were objections. There were maybe things to discuss, but we never got there because a motion to dismiss was granted.
But your point is discovery response was timely filed.
That's correct, Your Honor.
Whether the 5D would have thought that was sufficient is another issue.
Yes, and I do think it's ultimately irrelevant because motion to dismiss was granted. But and as was noted in prior argument, motion to dismiss was based on a reading of a lease. It wasn't you didn't properly plead, something or something that could be fixed with an amendment. It was applying the clear provision of this. It's not a lease. I apologize. Purchase and sale agreement.
The part that said your partners, affiliates, and agents cannot be held liable.
Correct, Your Honor.
For the acts of the contracting parties.
And one of the things you'll see in that timeline I pointed you to is, and I recognize present counsel wasn't around at this time, but it was not a surprise that we filed that motion. That exact same argument had been previewed by Mr. Catone in opposing the amendment. And that's in the record, that they opposed the amendment And the Chancery Court heard that same argument, that this would be futile.
So they
because
should have
of this
been
provision.
ready for the notion that, hey, these parties were actually assignees and prepared to present some proof on that.
That's right. The Chancery Court said, you're not the right party to bring that. It was basically a standing, is why Mr. Catone didn't win that. But if everyone knew, as soon as we got in, we were going to raise the same argument. So this idea that we had somehow agreed to waive that motion and asking for an extension does not comport with the record.
And had you not filed a motion to dismiss, but filed an answer and asserted the very defenses you raised in the motion to dismiss, then 30 days later, you could have filed a motion for judgment on the pleadings. You get the same result.
That's absolutely right, Your Honor. That's why we think these are gamesmanship to deal with these motions, because that's absolutely right. That's what we actually did when all these motions came accusing, trying to get sanctions, all sorts of extreme remedies. One thing that's in the record is we went ahead and answered. After our motion to dismiss was already pending, we said, look, we'll moot one of these. Let's file an answer. It was in there. So if the Chancery Court had decided at that hearing, look, you've waived the motion to dismiss based on this language, the next day we would have just filed the exact same argument and a motion for judgment on the pleadings, gotten under the same standard and gotten the same result. All the particular motions are premised on the idea that the order was violated. The motion to strike the answer, the motion for default, the motion for sanctions, all these motions, the threshold initial premise of them is that we violated this February 2024 order, which we don't think we did. And the Chancery Court clearly found, and it may not be in the wording, but based on the ruling, that we did not violate that order because she granted the motion and heard the motion and denied these others. And as noted, it's also not supported by the law that we violated that order based on the Ayler case and the lack of any cases outside of Rule 15. So without that threshold issue, the notion that the Chancery Court had to go through each of the elements of sanctions, of course she didn't, because she didn't find that there was any order violated. So why would you need to go through whether it was a knowing violation and all these other factors? So that's really a red herring argument. Unless your honors have other questions on that point, I want to move to the issue we raised on appeal, which was the Tennessee Code Annotated 2012-119C1. And our motion to dismiss does not cite that provision, that subpart, and say we're going to ask for fees. The Chancery Court found and repeated this finding in denying the motion to revise, where it came back up, that in order to get fees under that statute, the Chancery Court believed you had to mention it in your motion in order to give notice to the opposing side that they should consider withdrawing their, non-suiting. Respectfully, we believe that's not what the statute says. That's not what the intent of the legislature is, and there are multiple Court of Appeals opinions that make very clear under the statute fees are mandatory. It's not discretionary. So if the court otherwise affirms the dismissal, we respectfully request that the court direct the Chancery Court that fees can be awarded, should have to be awarded, mandatory, under the statute, even if not mentioned in the motion. And of course, we'll need to file a motion with our amounts and the reasonableness. We'll have a hearing on all that. But the Chancery Court has already directed in 2 orders that she does not think we are allowed to get attorney's fees because it was not mentioned in the motion. And we respectfully ask the court to correct that in its opinion. Thank you.
Thank you, Mr. Farringer. Mr. Kelly, your rebuttal. Did Mr. Farringer's clients or the third-party defendants file discovery?
I will defer to Mr. Farringer on that. I apologize if I misspoke.
All right, very good.
But I trust him to
That's fair.
represent that fairly to the court.
Thank you, sir.
I just want to point out, one, on this issue of the attorney's fees, there are exceptions listed in Section C of that statute that provides for attorney's fees. And the trial court noted that under C5C, that's where it enunciates that, you know, as long as the person making these claims withdraws their complaint within 3 days, that they can, there's no basis.
They're
for
not
these.
liable
They're
for
voluntarily
attorney's
allowed to
fees.
do that.
Correct.
And I think that's where notice, again, is important. If someone doesn't say to me, we're moving to dismiss and we're asking for fees, that's not necessarily a consideration in our assessment of what to do, what's best for our client. So that's where notice is important, which ties me back to our overall argument here, which is that procedure matters because of due process. Had the court laid out the factors, gone through the assessment of our requested relief, then said, nope, this motion to dismiss is carrying forward, then they could have figured out a way. They might have chosen to amend. They might have chosen to withdraw the complaint. But the way that it was handled in that order certainly negates the notion of fees. But again, I think the court should have assessed those and given 5D the opportunity to make a decision on how to proceed based on its procedural arguments.
And you talk about procedure matters. In regard to the attorney's fee, the word shall matters. How do we deal with the word shall based upon your argument?
Well, it is a shall, but there are exceptions.
Well, if you're a state entity, if the plaintiff drops the suit within 3 days or whatever the timeline is.
Well, again, I think there
I
should.
don't think your client falls within those exceptions.
No, not those specific exceptions, but again, it's the factor of notion that we believe the trial court got that right, that there was no notice that they were going to proceed for fees if they won their dismissal, and therefore the fee should not be awarded. If I don't ask for something in my complaint, I'm not going to get it from the court or the jury.
All right, thank you, sir.
Thank you.
Thank you both for your arguments. We'll take your matter under advisement.